Can you refuse a blood alcohol test if you're pulled over on suspicion of driving under the influence? Well, of course you can. But what are the consequences? In the very important case, Birchfield versus North Dakota, the Supreme Court addressed this question. Can a state, without a warrant, take blood alcohol test, and if you refuse to consent to a test, can it criminalize your refusal? The Supreme Court stated that your refusal to take a blood alcohol test cannot be criminalized. Why is that? Because the Supreme Court stated that a blood test is more intrusive than a breath test. Refusal to take a breath test may be criminalized by state law, but a blood test involves the piercing of the skin, and it involves potential retrieval of information that is much greater than that would be revealed by a breath test. Therefore, a warrant is needed for the state to take blood test without your consent. Now, this case covers only the scope of criminal penalties. Remember that your state probably does have an implied consent law, because most states do, that if you refuse to take a blood test, your driver's license may be revoked or suspended. So the Supreme Court decision in this case does not stop states from imposing civil penalties for refusal to take such a test. It only stops them from adding an extra criminal charge for refusing to take a blood alcohol test. So, this is the significance of the case. It was decided by a 7-1 margin. The only justice to disagree was Justice Clarence Thomas, who is renowned for being really tough on crime. Justice Thomas argued that this creates an inconsistent standard. Blood test, breath test, to him, it's all pretty much the same, and he said this only confuses law enforcement. But notwithstanding Justice Thomas's dissent, the Supreme Court's message was very clear. If you want to take blood test subsequent to a DUI stop, you better have either one of two things: a consent of the driver or a warrant. And you cannot criminalize the refusal to take the test. Thank you.